Welcome to Clause 8, presented by TradeSpace, a revolutionary end-to-end AI-powered IP management platform that helps companies unlock the value of their IP. If you enjoy this show, please take a minute to subscribe on voiceofip.com for updates. Today's episode is the final one for this season of Clause 8, and we thought it was only fitting to end by looking ahead. To do this, we're diving into how the U.S. Patent and Trademark Office is undergoing a major shift under the current administration. After years of policy choices that weakened patent rights in the name of broader political goals, like lowering drug prices, the USPTO will need to refocus priorities in order to return to its core mission. Those priorities include helping innovators secure high-quality enforceable patents by reducing the application backlog, offering clearer guidance on patent eligibility, and pulling back from the agency's increasingly active role in invalidating previously granted patents. But it's not just a procedural pivot. It's a cultural one. As one of today's guests, Julie Burke, puts it,
when you train these smart, resourceful people to reject, what are they going to do when they get into the art units? They're going to continue to think that's the way they need to go forward. And that rejection culture, the churning happens. They can't pick up new cases. You see everything that goes on there.
We'll also hear from Clint Mehall in this episode. These two guests are two of the leading thought leaders in this space, and they have a lot to say about the USPTO in today's episode. So, as this season of Clause 8 comes to a close, we're reflecting on what the future holds for patent practitioners, innovators, and the IP system as a whole. And now, here's your host, Eli Mauser.
So this is the last episode of season of Clause 8. It's been actually our longest season. I think this is going to be our 21st episode. So I want to first thank everybody for listening to Clause 8. Thank my sponsor, TradeSpace, for supporting the season. And I'm excited to do this final episode. A few episodes ago, I talked about the new acting director, Coke Morgan Stewart, and I'm a big fan. And when I did that episode, I knew she'd be great, but I didn't expect the changes to be put into place so quickly. And there's been a lot of changes, obviously, in the administration as a whole. And I said, all right, we got to kind of wrap up the season, wrap up what's happening in this moment in time. And when I was thinking about this episode, I couldn't think of two better people to have on than Clint Mehall, who's obviously, if you follow patents, patent strategies, patent prosecution on LinkedIn, you've probably seen his name, read his posts. And of course, Julie Burke. And she's like, whenever anything happens at the USPTO, if you go to her LinkedIn page, she's already posted about it, covered about it, and has a take for it. I actually wanted to have her on for a long time, and she's writing a book in the process. But I said, I can't wait for that. I can't wait for that because this is such an interesting moment in time, and we got to talk about that. But before we begin and dive into all the issues that's going on, maybe Julie, can you share a bit of your story? You spent a lot of time at the USPTO. How did you become now writing about these issues all the time?
Thank you, Eli, and it's a pleasure to be on a panel with Clint again. I really appreciate that. I was 20 years at the USPTO from 1995 to 2015, started as an examiner in TC 1600. My technical area was cancer immunology. I quickly became a special program examiner up in management and a quality assurance specialist for 8 years. Tumbled out of the patent office, and Eli's correct. The book is coming. I have secured an agent, and we're looking for publishers, which is very exciting. But, that will take a year or so to get a book out on my experiences at the patent office. After that, I was a registered patent agent. I worked at Kenobi Martins as a patent scientist, and I saw that the difficulties I was witnessing in TC 1600, I thought that was just the only little twisted corner of the world at the patent office. But actually, there were things falling off track in the mechanical and the electrical areas, too. So that was kind of eye-opening for me. Right before COVID, I retired again and started a consulting business. I'm an expert witness in court depositions and write articles. You can find them all over the place. IP Watchdog, Law 360, The Hill. And I'll be speaking at the AIPLA spring meeting and a workshop on double patenting, and then the ACI conference in Manhattan in May on double patenting with Tom Irvine and others.
So what was your final position at the PTO? You were
I was a quality assurance specialist and also a whistleblower in trying to make changes within the administration. And that agency is kind of impervious to oversight. They don't do well with this. So I tumbled out, and now I am a whistleblower on the outside. A lot of freedom with that. LinkedIn. I do the LinkedIn work because I feel like our patent system is extremely important in need of reform. It's hard to find out what's going on inside and outside the agency. For folks to be able to make informed policy changes, it's very important. On the other hand, we also have our inventors and IP attorneys and agents who have to respond to office actions and are trying to get IP rights for their clients. And this is where Clint Mehall's approach, the data-driven examiner, all the procedures, trying to weave your way through the various procedural mechanisms to get the best result for your clients.
Yeah, and Julie, I appreciate that. And I've been reading your work for a long time, and sometimes it was like patent attorneys, we focus on the day-to-day, and I'm like, things can be as bad as Julie describes them, and then things happen, and maybe I'm like, seriously, it might be within the USPTO, so I'm sure your book will be fascinating on that. Clint, obviously, you're a fellow patent attorney focused on patent prosecution. I think I've talked about you before. You read opinions that come out of the ex parte opinions that come to decisions. You write a lot about that. But maybe you could talk about this moment in time a bit. What are you seeing these days? What is day-to-day of patent prosecution like in this moment in time?
Yeah, so I have a very boring history as far as most patent professionals go. I've been at the same firm for 17 and a half years, Davidson Capel in New York City, which was essentially started by a bunch of attorneys who worked at Kenyon & Kenyon, which was the huge patent boutique back in the day. It's no longer around. And one thing that I think I got from being at a smaller patent boutique my entire career is I generally didn't have anyone dictating strategy in a specific way. So I could play around with, does this work? Does this work? Had flexibility to file a lot more appeals than I think average patent attorney did. One of my mentors was huge on filing appeals. He was a former examiner and would just look at an office action and say, this isn't reasonable. We're not admitting the claims in response to this. And he was also in the midst of a litigation at the time, which really put the idea in my head that you shouldn't be narrowing claims for no reason. So I always took a super proactive approach with interviewing and appealing. I think I appealed more when I was younger, and I think I tried to interview a lot more as my career's gone on, because I feel like the thing that people don't talk about enough is the human component of patent prosecution. Examiners are different. They're trained to examine applications differently. With the analytics available now, you can see that allowance rates are all over the place. That's something that I think the next director should absolutely look at, is why is this certain examiner, or you have a 95% allowance rate and this one has a 50% allowance rate? Because that hasn't changed over the years. And since the data has been available, allowance rates are still all over the place. There's a ton of appeals that are making it ex parte appeals to the PTAB right now, which I think has a lot to do with the fact that there's a lot more junior examiners than there was in previous years, which a lot more applications are being filed. Of course, it's a necessary evil, but the SPs and whoever's sitting in on the appeal conference, I think, aren't necessarily weeding out appeals as they should be. Because if you look at the backlog on appeals, it's increasing and increasing. So I think the push for the new administration to deny more AIA trials like IPRs and PGRs, I think it could have a positive impact on getting the ex parte appeal numbers down.
Yeah, and I guess we'll talk about that. Obviously, there's a lot of changes with how the personnel are, but there's talk about moving some of the PTAB judges to the ex parte appeal side, which will increase benefit on that. Let's get to a big issue that's on everybody's mind, and we talked about is really the backlog. We're reached right before this administration a record of 1.2 million pending patent applications, and then the average total pendency is 30 months. Howard Lutnick talked about it at his confirmation about wanting to bring that down, and that's really a big focus of the administration. Acting Director Cook Morgan Stewart said that's a big focus of returning to the basics of examination, not being distracted by all that. So, Julie, how did we get such a huge backlog? And what do you think about what's going on now in terms of fixing that issue?
Oh, great questions. Obviously, the problem with the backlog is it's delaying people's rights to have their patent applications examined in a timely manner. And it also adds to morale problems at the patent office. And the hiring freeze was the first big problem I see coming in with the new administration. The PTO's plans to get the backlog down, they had plans, they were trying, they were working on it, was to hire 1,600 new examiners. That's not happening. The second problem with the backlog, and they have been hiring examiners last few years at record numbers, is the 40% attrition rate at the training academy. That's through the roof. These are people who've been vetted and hired, who have the right technical background, made it through all the hiring processes, and 40% of them are not making it through the first year of training. That means something's not right there. It's very telling at last week's town hall meeting, the leadership, it was either the Commissioner of Patents, Valencia, Martin Wallace, or the Director Stewart, said that this time they're going to try to hire, when they get a chance to hire, examiners that want to work at headquarters. And that already cuts down the panel of people available to work in the DC area. But this whole return to work thing will still be affecting the patent office, even if the patent examiners right now can remain in their hometowns and work where they've been working for years. The word also out was this time we're going to hire the right people. And patent examiner morale, it's like saying that now we're going to hire the right people, sort of insinuates that maybe they hired some wrong people. And it's very hard right now, the patent examiner position. They're not getting support from the agency. They're not getting support from management. They're facing incredible hurdles in the day-to-day workload. My best advice for people like Clint Mehall, who are actively prosecuting cases in front of the examiners, is to reach out and begin the interview with extending concern and sympathy for the situation that they're in, and saying that the patent bar does support the examiners. And this is kind of a crazy workplace situation they're all in.
Yeah, but I guess it's important from my perspective that backlog really hit the record in the last administration. There's an explanation for that, but I think it is fair to say, and I think what this administration has been doing is, hey, the USPTO wasn't really focused on examining. They're focused on maybe rejecting claims and all these other initiatives that they had. And one positive experience that I had, and I guess some mixed experiences, one is I think there's more of a focus of, there's obviously some supervisors, for example, in the business method art units. I've been working since Alice came out, so for over maybe 10 years now. And now I had experience, I know it's anecdotal, but I presented an argument why something's patent eligible under 101. The supervisor said, oh, that makes sense. And he made the examiner withdraw the 101 rejection. On the flip side, and I want to get Clint to kind of comment on that, the other thing I'm seeing is, another thing they're doing is making sure that the examiners keep things moving, right? And as part of that is they have less time for some things, maybe less time to provide training, to consult others, but also after final office action, right? After final, the last administration got rid of the AFC program. And now they're like, if you file a response after final, chances are we're going to have to issue an advisory action just to keep things moving on the docket. Clint, have you been seeing that? Have you been seeing a change one way or the other in terms of what's going inside to kind of work through this backlog?
Yeah, so it is a shame that AFCP 2.0 was done away with. I think it was useful in a very limited amount of spaces. If you're trying to amend the claims substantially and put in new arguments, technical arguments, you're really just taking time away from the examiner, because the examiner didn't get enough production credits for it. And you essentially were not paying for examination time you were getting. But the fact that it's unavailable now for something that the examiner, you agreed to on an interview, the examiner can take a look for 5 minutes, and the examiner doesn't have the option, essentially the examiner's supervisor or the examiner itself is going to make you file a RCE, which RCE fees are going up. So if you're on your second RCE, it's over $2,000 now. That the rates have gone up substantially. There should be some type of middle ground option. I know it was tossed around that you could file under the AFCP 2.0 and that there would be a fee for it. I think that would have been the best option. So you're paying the office for the examination time, so you don't have the budgetary issue of examiners working and not necessarily getting paid for it, but you're also not getting stuck with the full RCE fee. I think that would have been a fantastic middle ground. It doesn't really make sense that it didn't move forward in that way to me.
Yeah, and I did statistical analysis for the AFCP, and I think it was a really good idea, but I think statistically, filing an AFCP improved chances of allowance by 10%. But here's a problem that I'm seeing, right? If an examiner knows a case is likely to be allowed, right? But he's right now being incentivized to issue an advisory action instead of allowing it. Then that adds to the backlog problem. Julie, what do you think about the AFCP program and incentivizing the examiner to allow a case that they know should be allowed instead of issuing an advisory action?
What incentivizes the patent examiners is their performance and appraisal plan, the bonuses, the metrics, all of that. And if we delve into that, you'll find out AFCP 2.0 is not a category in there. It's a pilot program. And we do have some long-standing pilot programs at the USPTO. What's interesting about pilot programs, they can be put in place without the union's buy-in. To make it a standard program where the examiner would receive some sort of credit for handling the AFCP 2.0, you'd have to have PTO management go into negotiations with the union and make it be a line item in there. They'd get some certain amount of something. So right now it had been handled art unit by art unit, numbers of hours are not very inconsistently across the board. They've canceled that one out. I do believe the backlog in part has been exacerbated by the 2020 reforms to the patent examiner's performance and appraisal plan. A lot more emphasis, money on the line was given to timely moving cases, fastly moving cases, and just punting it out the door with the next quick action. For the examiners, they were getting more docket management points. This is leading to cash bonuses and not looking at the whole big picture of getting to the end of prosecution.
So that's actually two interesting points. There is one that explains why the FCP program remained as a pilot so long, and then it was a really good idea, but it wasn't implemented as well as it could be. And then the other thing is that maybe there's some incentives that the examiners have to just issue another action instead of getting to a resolution with the prosecution of an application that's causing issues. Clint, do you have any thoughts about things that maybe could be done to kind of move quicker towards allowance, or an examiner or an applicant realizing that they don't want to pursue an application?
So I think there should be a stronger emphasis on trying to identify allowable subject matter in a first office action. If you could have the examiner honestly even comment on something that's in the application or minor amendments to the claim. There's an examiner that I deal with quite a bit, and he has an interesting history in that he was an examiner for years, and then he worked as a patent agent for years, and then he went back to being an examiner. And I talk to him all the time on the phone. One of the things he told me is that for the newer examiners in his art unit, they complain about the applicant's arguments and say, well, if they just changed the claim slightly or added this additional limitation, I would allow it. And his response is always, did you tell the practitioner this? And of course they did not. And if you don't ask examiners specifically on the phone, and I know Eli's talked a ton about, be straightforward with the examiner. If the examiner's not buying your arguments or amendments, then ask the examiner what the examiner would allow. So I think that they could put a really strong emphasis on that and trying to give the examiner sufficient time on the front end and rewarding the examiner for identifying allowable subject matter. Obviously, you don't want examiners to feel pressured to identify allowable subject matter if nothing's allowable. But I think searching's difficult. Examination is difficult. If the examiner's not finding good art and searching and finally finds something for the independent claim to issue an obviousness rejection, and then the examiner's going through the dependent claims, a lot of times the examiner was not incentivized to take the dependent claim seriously. So there's something that you end up like on the third office action and you put subject matter of a dependent claim in an independent claim and the examiner allows it, which is just insane. Or you end up appealing a rejection and arguing, this is something I do all the time. I file an appeal, I argue 5 dependent claims, and the examiner gets to the appeal conference and is like, oh yeah, I'll allow that claim. And if that could have happened substantially early, it would help the backlog quite a bit. It would help applicants spend less money, which is always important.
Yeah, and I think there's two dynamics to that, right? So when an examiner rejects all the claims, if there's a dependent claim, they feel like they need to reject all the claims sometimes, right? So they don't put a time in the dependent claims, but it should be all right. Like, no, if you can't find art for a dependent claim, it's okay to indicate it is allowable. So to create the permission structure. And then the last big backlog that happened was right before David Kapos came in. And I think the emphasis that they put there is on doing interviews working with applicants. And then also, I think, going to what Julie was saying, I think they changed somewhat the credit system that the examiners were getting. For subsequent rounds of prosecution, they would be getting less credit, or maybe just a final off section. Julie, do you have any thoughts about that? Maybe, is there a way to change the structure from that perspective, that examiners know that a second round of prosecution is not the place to be, or something like that?
Those are clearly interesting concerns, and the credit system drives the patent office examiner's behavior for sure. I think the more crying problem with the backlog is the proportion of junior examiners we now have compared to senior examiners. And in areas like AI and electric vehicles, it's even more skewed towards junior examiners. And I have read heartbreaking posts on Reddit, and examiners have reached out to me during Training Academy. There's a culture of not training junior examiners how to find allowable subject matter. They're to reject their way through for the first entire year. And when you train these smart, resourceful people to reject, what are they going to do when they get into the art units? They're going to continue to think that's the way they need to go forward. And that rejection culture, the churning happens. They can't pick up new cases. You see everything that goes on there. Our problem also is the GS scale. The new examiners are coming in at GS 7 and 9, and I know those are just numbers to people, but they do not receive negotiation experience till GS 12. Your GS 9 junior examiner cannot find allowable subject matter and communicate that to applicants. They need to have a primary examiner, a mentor, sitting with them and telling them that, yes, this is allowable. It's that idea when you go to interview a case, make sure the deciding official, which could be a primary patent examiner assigned to the case, or it could be the SPE of the art unit or a primary examiner sitting in on the interview, so you can actually make these decisions. You've got somebody with authority to allow a claim. Our problem right now, though, is other time is being cut. The primary examiners are not to be training and sitting in on interviews as before. The supervisory patent examiners, I hear they're doubling up on art units. There's been a real attrition of high-level seasoned examiners getting ready to take the fork and retire. It's a big push for this. And so that ratio of junior examiners to senior examiners getting even more skewed.
Let me ask, since you mentioned the AI piece, one of the things that I've written about it is that during the last administration, and I think that contributed to the rise in the backlog, is really the dramatic increase in 101 rejections. From what I've seen, actually, between 2019 to 2024, it rose overall in the USPTO from 10% to 24%. And in the AI art units, it rose from something like 38% to nearly 80% in 2024. So dramatic. And once again, if you have new examiners who are trained to make 101 rejections, that's how we get there. But one of the reasons that I hear from examiners is the reason that there might be a shift is because of a 2019 guidance came out that example 39 for how to treat an AI claim. And then they had these new examples that the last administration put in, example 47, which in their mind supersedes the old example sometimes. And there seems to be confusion. Do you see an issue, I guess, between those examples that maybe don't provide the clarity necessary for examiners?
Absolutely. Is that all? No. Yes. No, it is a huge problem. I have a claim that we won an appeal on 103, and the board entered a new ground of rejection under 101, and our claim was relatively broad. So in the first office action response, we added structure of the neural network. We added the convolutional layer performing certain functions, and the examiner has continued to reject it, saying that the convolutional layer is old and well known and that it doesn't describe how it's performing the function. And I pointed to this example and some PTAC ex parte appeal decisions relying on example 37, and the examiner continues to point to the new examples, and he points out that the neural network in example 37 dealt with audio, which really isn't in the reasoning of the examples. And also, if you look to PTAB ex parte appeal decisions, because as Eli mentioned earlier, I read them on a daily basis, particularly 101s and reversals on obviousness grounds.
I think you're referring to example 39, right? With the images.
Yeah. Sorry. Example 39. And honestly, they're all over the place of whether a neural network or large language model or reciting some type of artificial intelligence in the claim makes a difference. And you have some PTAB decisions that will point to example 39 and reverse the examiner. And then you have other examples that completely ignore example 39 and go into the old and well-known logic for neural networks, which it's similar to saying that if you have a system for driving a car, that the gas pedal is old and well-known. That usually should be sufficient. And as another example that's a little off track of the AI stuff, but I had an appeal win a couple months ago for a method of operating a nuclear reactor. And the way that the reactor was operated, it was trying to reduce something called pellet cladding interaction, which is a huge problem in nuclear power. And the way that they operated it, it was safe, but not as restrictive as the prior art. We ended up winning on ex parte appeal, but there was a judge that dissented and addressed an argument in my brief related to Diamond v. Deere that it was the closest possible case. And the dissenting examiner came back and it said that Parker v. Fluke was the closest case. It's a huge problem within the patent office that, first of all, that a judge could come to that conclusion. The second, that 3 judges can sit down and can't reach an agreement on something that should be so blatantly patent eligible.
Yeah, and the USPTO has withdrawn some of the guidance provided to examiners and judges in the last administration. And maybe this is another area to look at. Maybe withdraw those new examples and issue some more clarity about what's patent eligible under 101, so we don't have these kind of, it's a waste of resources, obviously, for this judge to dissent on something that, if the USPTO thinks that should be patent eligible.
Yeah, so I saw Coach Stewart speak a couple of weeks ago, and someone had asked a question whether the office had thought about considering doing director review for ex parte appeals. And she said that nothing was currently in the mix. But she drew the attention to something called the ARP, which is the Appeals Review Panel of the PTAB, which is something that I didn't know existed. It's only done sua sponte by the director. But I would love to see the new director go through and take a further look at some of these 101 decisions and I think that'd be a fantastic way to give clarification. You can put out a million examples, but having a case that was argued back and forth by the examiner and the applicant, I think would provide a ton of insight to practitioners and applicants on what is patent eligible.
Yeah, I agree. And maybe if there are better one-on-one rejections, it's a good way to rein in that. And Julie, you've been breaking some of the news about the personnel changes. I think you mentioned the new acting commissioner, Valencia Wallace Smith, obviously a veteran of the USPTO. I think she led a lot of DEI initiatives in the last administration and the tail end of the one before that. But she does have experience focusing on quote-unquote quality and so forth. Do you have any insight about why she was chosen? And I guess, what do you think about the task on her plate, the backlog issue, which is obviously a very big issue, and that she has to draw on her experience to find a way to solve that?
She certainly has had experience in the office, and seeing several administration changes, was in the office when we had the huge backlog when David Kapos came in and we tried to tackle that backlog. So she's familiar with the mechanisms for how things can get out of control and how management can work together to try to herd the examiners to certain behaviors or not. The biggest challenge facing right now, coming in with this new administration, is encouraging senior people to retire, offering buyouts, offering forks in the road, offering voluntary incentives to leave. Second big problem is that these managers are being called back to work in the office, and quite a few of them can't uproot their family and kids from school in Illinois and move back to DC on short notice. The people who would have to implement changes to review appeal briefs better, have more consistent examination, train the examiners, do all the handwork that we're talking about, are not going to exist in those positions. Right now, they're offering supervisors, quality assurance specialists, people that are patent attorneys at the board, petitions examiners, the chance to return to an art unit and pick up a docket. Front line, shoulder to the wheel, everybody working patent applications. So who is going to be there to try to guide these examiners into doing different things? There was an Inspector General report during Kathy Vidal's administration on patent examiner decision-making. This comes to the point where you can have examiners in the same technology, and some have an established 10% allowance rate over the last 3 years. These are the patent bot stats, and some have an allowance rate of 90%. And how can that be? And the Department of Commerce Inspector General called on the Patent Office to rein this in, to put some guidelines on, to do something. And I have not seen any change to those stats or any change. It's in a way, Commissioner Valencia Martin Wallace has 9,000 patent offices to manage. They're each running their own little shop. Each art unit's running its own thing. Very difficult for practitioners to deal with, but really hard on the patent examiners too, because they don't know the policy du jour. They're really running in different areas.
Yeah, from one point is they had all these people in these positions, right?
Yeah.
To provide this kind of guidance to examiners, and the result was we now have this huge backlog. I think, from my understanding, is they're trying to like, hey, let's keep the examiner corp as large as possible and at least get through these applications. But what you're saying is, especially like we talked about, there's all these junior examiners. You can't have one commissioner, 9,000 examiners. You're going to need people in between to make sure that the cultural changes that need to happen to get through this backlog happen, and not having those people in the right positions might interfere with that. Clint, any thoughts about that? I know actually before we started recording, you were talking about recently dealing with the quality assurance specialist. So that's the role that we're talking about. But anything in general about what can be done so the examiners have the morale and the tools necessary to examine applications in the best way possible?
I think there just needs to be an increased emphasis on searching ability. I think the prolonged prosecution histories are a result of examiners not necessarily being the most fantastic searchers, and they go to their supervisors or primary or whoever's above them and say, I searched for this and I can't find it. And the supervisor of the primary says, you know what, that's out there. I know I've seen it. Keep searching. Or put together a rejection. So what they do in that instance is they interpret the claim language more broadly than it should reasonably interpreted and issue rejections. So then the applicant is either amending claims or appealing. And then it makes, for example, I've had cases that it makes it up. You file an appeal brief, the 3-person panel that sits after the appeal brief, they take a look at it and they say, okay, yes, this is a bad rejection. Let's do more searching. And then the examiner does more searching and comes back with substantially better art that should have been caught on the first instance. So I think an emphasis on searchability, and I think AI tools will help quite a bit with that. That should be something that gets better over time. Also, making sure that all of the quality assurance specialists or everybody above is on the same page. There's an art unit that I practice in quite a bit that it's not a software-based art unit. There's not a lot of software-based applications in it. So when something comes up, the quality assurance specialist gets brought in and advises the examiners on it. And there's just one quality assurance specialist that does this. And I've heard this quality assurance specialist is referred to as the 101 expert. I had an application that was directed to a manufacturing process, and there was a manufacturing step at the end. And I had a call with her, argued with her for an hour about Diamond Vidier. We ended up appealing it and won. And now I had a call last week with an examiner in the same tech center saying that for a claim that we were going to add a manufacturing step. And he's like, I don't know if that's enough. And I said, who's your quality assurance specialist? Is it this person? And he said, yes. And I said, why don't you take a look at this appeal decision? The fact that one person in an entire tech center can hold up after one issue that is not consistent with the law is pretty troubling.
That's interesting. And actually, it's a good point to point that I've had very good experiences, obviously, with some quality assurance specialists and management quality assurance specialists actually putting the examiner and the supervisor on the right track. But if you have another quality assurance specialist who does the opposite, next time they pick up a case, they're just going to refer back to their previous experience. If they're put on the wrong track, that's kind of what they're going to think about. And Julie, you obviously were at the PTO. Any thoughts about that dynamic? How do you make sure that there's not somebody who might be steering examiners in the wrong way?
So we have to roll things back to 2010. I was a quality assurance specialist before and after 2010. I was in management before 2010. Under the POPA management agreement overnight in 2010, quality assurance specialists, petitions examiners, re-exam examiners, reissue examiners, the patent attorneys that ghostwrite at the PTAB, these are the people that assess the correctness of the patent examiner's allowances and rejections. Overnight, we were moved into the POPA union. And that had a chilling effect on us and what could happen. We were no longer in management. We were in the union. We weren't in the management meetings. We weren't able to say, if you have this policy decision, it's going to change things. We were totally, all our teeth were taken out overnight. And we tried to appeal that up. And the National Labor Relations Board said, as employees who do not directly supervise a person, we probably could belong to a union, but it's a blatant conflict of interest to be in the same union with the people whose work you oversee. What happened right after that then was the patent examiners and management got together and rewrote our performance plans. So we were given less time, less incentives to do deep digs and to try to resolve problems. And as a fellow union member, we're sitting on an appeal board looking at the examiner's answer potentially. We didn't have any ability to say, we really should open this up or these claims are allowable. They took that all away. And it'd be really wonderful for the new administration to take a look at this funny arrangement and see if these pseudo managers really should be in the POPA union. That's one area where I feel like more people then could stand up and respond adequately and make sure that the things get done right.
Yeah, and I guess my experience is that sometimes examiners and supervisors even want that kind of firm guidance. Do this or don't do this, right? And if we're not given that, it doesn't help.
I can speak to that as a quality assurance specialist. We all wanted firm guidance. The patent examiners have to go out on a limb in writing every day, every application, office actions. They have to make positions and put positions in writing. And it was very frustrating as a quality assurance specialist when a dispute might come up onto what we should do with regard to a 101 rejection or something. If we reached out to the legal shop, case by case, guys, you guys figure it out. They would not put an answer in writing to us. They would not say, yes, we believe in this area, this should happen. They were not going to create any paper trails. And so it left us hanging as to what do you think we should do? And I'm not an attorney. Most of the people that are supervisors and quasses are not patent attorneys. We're just trying to do our best in this situation with limited guidance.
Yeah, I would love to follow up on that point. Just referring back to the quality assurance specialist and the PTAB decision, I think that there should be more interplay between the PTAB and the examiners as far as ex parte appeals and even post-grant proceedings. So if an examiner loses an appeal because the examiner's standard of claim construction is way off, then there should be some type of feedback. And examiners are trying to get it right. I think overall examiners do a fantastic job. They're hard workers. I think they take their job seriously, but a lot of times they're in the dark about things. That obviously not all case law that the PTAB uses is in the MPEP. There's a ton of case law that I frequently cite in appeals that should be in the MPEP to better guide examiners and put limits on what is obvious and what is not obvious. If you can provide that information to examiners, I think they'll be happy about it, and I think you'll have improved results.
During the last administration with Director Vidal, the Patent Office created a outreach, customer service, publicity branch of the office that employs 200 employees.
Wow.
Meanwhile, the Office of Patent Legal Administration is down to 37 employees, and those are not just the attorneys. That number 37 includes clerks and paralegals. These, I'm guessing about 25 patent attorneys in OPLA absolutely are, their duties are varied. One is in updating the MPEP, preparing training materials for the examiners. By the way, all training's canceled. Don't think that's happening. There's a variety of ways where they have been seriously muzzled. So what would be awesome, these things we talk about, we don't have and will not have the people sitting behind the desks to be the quas, be the SPE, to rewrite the MPEP, to look at the PTAB decisions. That is all being gutted right now.
Those are pretty startling statistics. 200 people, I guess, doing PR for last administration, 37 focused on probably the most important
Yeah.
part of a PTO. Another thing we saw at last administration, this actually brings me to mind what Clint was saying about the emphasis on searching. I was talking to somebody actually from the big tech community, and their complaint was examiners at most have 30% of their time to spend on prior art searching or one of three rejections, because I believe that statistic because now they were asked to make 101 rejections, 112A, 112B rejections, novel double patenting rejections, about like very arguable things that you don't want examiners really focusing on these kind of edge issues that the last administration was putting in. And I don't think this training was sufficient to really educate them what to do. A lot of their time was spent not on searching and not on prior art rejections. And I'm like, that's really should be the focus of examiners, is finding the best art up front and then using that throughout the examination.
Yeah, I feel like 101 rejections are often used because the examiner can't find the best art. And it's software. Software stuff is hard to search. It's not like searching chemical. There's not a specific nomenclature for everything that's in a software patent application. A lot of times it's the drafter or the client creating their own terminology. That's something that I think AI tools could really help software searching and could completely eliminate the need for a 101 rejection.
What I'd like to suggest that the new administration do is take a step back. Our examiners are hired with a technical background, areas of expertise. They're put into training academy, and a common complaint is I've been assigned an art unit outside my area of technical expertise. Imagine how hard that is. And then these examiners land in these art units and get docketed cases. A huge complaint across the patent examining corps in the last 5 years, I think this attributes greatly to the backlog, is the idea that they've switched over to a different way of classifying and assigning work to examiners. And the cases that come onto their desk aren't coming from their supervisor who knows their specific technological background. They've got this AI figured out CPC search code thing. And examiners talk about beginning each bi-week, picking up applications and having to send 2 out of every 3 back into the pool to be transferred to somebody else because they don't work on those things. And junior examiners have the least ability to turn down work. They're the ones then that pick up things outside their tech area. That makes it very hard to search and examine. And there's been a Department of Commerce OIG reports looking into this whole docketing system. And even right towards the end of her term, Director Vidal recognized they had a very flawed docketing system and trying to get the right cases to the right examiners. A very simple fix that Acting Director Morgan could do tomorrow is this idea that with the new performance plan, the examiners were all put on a short docket, like 16-30 cases available to be worked on this bi-week. Examiners want a great big thick docket, 50 cases, so they can look through and say, oh, these 5 are related. I'll work on them together. I'll do the searches together. They know this is more efficient. That's how it used to be managed back in the old time. But here they're getting slivers of work and trying to jump from one area to another. It would be if the examiners could actually manage their docket and be given 50 cases at a time, they would work more efficiently. And in the biotech, chem, pharma area where a lot of the searches are non-patent literature searches or sequence searches, it would involve the examiner on Monday picking up a new case, realizing we need to send this out to STIC for some further searching, waiting 5 days to get those results, and then next week working. If they could do that way in advance, have 50 cases and more efficiently work as a batch and send out the results, gather them up. So when they pick them up, they're ready to be worked on, more thorough searches, a better chance to do a iterative search if the first search didn't show up what they needed. Those are very simple management techniques that might really help the examiners more efficiently handle this backlog.
It reminds me actually of another rumor, and Julie, you probably know that if it's a rumor or fact. I heard is that the continuation applications are now being moved down the docket. So before, it goes back to what you were saying, a parent application gets allowed, applicant files a continuation. The examiners obviously very familiar with that application and they could quickly dispose of it. Now they'll be picking it up maybe in 2 years when they've completely forgotten it. And that seems you're contributing to the overall backlog. Julie, have you heard that?
Yes, I have. But speaking from American inventor points of view, my research into the databases and watching what the examiners are allowing, you can read about it on Reddit where there's patent exams with a pipeline that never pick up a brand new case. They're just first action allowing all their continuations. They're in the glory days of their pipeline, just stamp out another allowance. And so that policy does have implications in that people with patents get more patents. But if you have not yet got your first patent, you're at the back of the queue on that regard. So by making them pick up those brand new first new inventions might help the American economy, help us get some competitive technology right out the door instead of giving a big pharmaceutical company their 37th patent on the same drug.
Which is important, obviously, but I understand the dynamics are a little maybe more complex. Clinton, your thoughts about that? How do you balance all that and make it efficient, but also give those applications allowed?
Yeah, that's honestly, I think it's something that you have to balance. I think there needs to be a balance between examining continuation applications and new applications. On the one side, if you're a startup company that's selling a product and you're trying to compete with one of the big boys, you have to have, honestly, years and years of continuations so that you can keep wraps on the market that you invented and help create. But at the same time, from the American public perspective, I have clients on both sides. We advise clients on whether there's infringement risks. So if it does create a lot of uncertainty if, for example, you file a continuation application and then it's not examined for 2 more years, and you file another continuation application that's not examined for 2 more years. It creates a lot of uncertainty of what's going to happen with these rights. Of course, you can look at the spec and advise your client that they have not claimed this, that even though it's in the application and there hasn't necessarily been art cited that's relevant, you can advise, but it's something that just really needs to be balanced. I don't have a quick fix on that one.
Yeah, and obviously the track 1 con option still exists to file track 1, and then if you have resources, then you could still get that examined quickly. I obviously one of the big changes we've seen in the quick movement from the new administration is really the work they've been doing to get the PTAB on what they think the right track is. Michelle Lee, when she was director, she famously said that the high rejection rates at the PTAB were maybe above her pay grade. When Joe Mattal came in as the acting director after that, he said, I don't want to touch any of this as acting director. Koch Morgan Stewart has taken pretty swift action with regards to that. But first, I want to talk a little bit about the statistics. During the first Trump administration, the institution rates went down from 67% in 2016 to 56%. And then invalidation rate went from 69% to 55%. And in the last administration, the institution rate actually went even higher than it ever was to 68%. And then all claims and validation rate to 70%. So obviously big jumps, consistent with the reputation that the PTAB has in terms of high rates of invalidation. And there were lots of complaints about this. And Koch Morgan Stewart has taken 2 actions that I think, 3 actions now, that are pretty dramatic that I think in terms of reining that in. One is the rescinding the memo about, not applying the FinTech factors and allowing discretionary denials. The second was that she said she's not going to be doing a direct review for discretionary denials, which I think it sounds a pretty strong message that she'll be personally involved and it's not going to be above her pay level to weigh in on those things. And then third is that obviously the dynamic we talked about where they're trying to preserve the examiner's corpse. I don't think they have the same interest in terms of the PTAB in that they're both giving incentives for PTAB judges to retire early if they want, for example, but also if they want to switch from inter-party review to ex-party, I think that's an option as well. So maybe, Julie, do you have any thoughts about those dynamics, about the PTAB, and where do you think this will all end up?
Will there be a PTAB? I think we should very carefully watch the dismantleization of the trial portion of the PTAB. That is exactly what's happening. Don't underestimate the return to the office mandate. There could have been a way the new director was able to spare the PTAB judges from returning to the office. That did not happen. PTAB judges are more experienced and closer to retirement, and all of them are eligible to get a very nice position out in the private sector if they so wanted. second part of this is offering the PTAB judges the right to go back to become examiners. If they want to stay, they would not have to return to the office. They could pick up a docket. And that would only be available for the PTAB judges that grew up through the patent system and had become primary examiners. That used to be the old way to become a PTAB judge, but since 2010, they've been hiring more people from outside who have absolutely qualified IP attorneys, but never had signatory authority. The PTAB, wow, I feel like we're really returning to a time when we had re-exams. And there were commissioner-ordered re-exams, and the mechanism did exist because we know a patent can issue, and it can be a bad quality patent. We're all human. That can happen. And we had a mechanism in place where the commissioner could order a re-exam on that patent. It went before a panel of 3 senior patent examiners who were experienced in that particular technology. And this was a very rarely used program. This is just a little escape valve if it was just some crazy thing that came up like curing the common cold, and they could throw it into re-exam. I think it'll be very interesting to watch what's coming forth these days.
My understanding is obviously the concern is that the duplicative nature of some of these PTAB proceedings, if there is a litigation going on, a district court litigation, the question is, should the patent owner then also have to defend that, the validity of the patent to the USPTO? But Clint, I guess any thoughts, about these changes?
Yeah, honestly, I think they are moving in the right direction. From my understanding, the AIA created inter-parties review and PGRs was to get rid of these garbage patents that shouldn't have been issued. So if you have a completely garbage patent that shouldn't have been issued, why do you need an expert that's introduced? You have technical experts as judges at the PTAB. They should be able to identify, based on submissions to prior art, that yes, this is a garbage patent. It should not have been issued. So I think, number one, if you want to get rid of the duplication and you want to make it less expensive as it was intended to be, then you remove the experts from the process. And also, I think there's been way too much leeway, which is also tied into the expert of filling in
Sorry, Clint,
evidence.
I just want to clarify that a bit for people maybe not familiar. You mean the experts when somebody challenges a patent at the PTAB, then they are able to bring an expert to fill in the gaps that the prior art might not do on its own if without that. Is that the kind of thing you're...
Exactly, yeah. A paid expert from the parties. Like one of my patent law professors in law school would say, for every expert that you can get in a patent case that will tell you today's Monday, you can find another expert that will tell you it's Tuesday. And obviously, you can evaluate the logic and the evidence behind those, but it seems to be causing patent holders to spend extra money on the process, which really just favors large companies that have a lot more money to spend, as opposed to patent owners or small businesses that have less money to be able to battle it out. If it's 2 large parties, I think there's less of a concern of the imbalance in that respect. But if it becomes just a way that you make the patent holder spend a ton of money on an expert to defend the patent, it seems like if it's some garbage patent that shouldn't have been issued in the first place, that's completely unnecessary. And then in tandem with that, I would also like to see the PTAB honestly go back to the teaching suggestion motivation test. I think that there should be more reliance on what is actually stated in the prior art to invalidate patents, because it's almost always invalidating a patent as being obvious. And everybody that gets sued for patent infringement always thinks to themselves, this patent's obvious, it shouldn't have been issued. And of course, every patent holder thinks that it's inventive. So if you're just bringing in experts or relying on common knowledge in the art, or I think that you're getting outside of the statute of getting rid of these garbage patents. I think that the teaching suggestion motivation test. So obviously this is not what's being done by the current administration, but I think it's a way to minimize the duplicative efforts and to minimize patents that aren't these garbage patents from getting invalidated.
Yeah, and obviously, that stems from case or decision. But if there's a way to maybe change the culture, I guess, the PTAB as well, in terms of how PTAB judges apply that. The counter argument to all this that I hear, I think this is a reaction to what the PTAB has been to try to clean that up. And this is what this administration is doing, and they should become commended for taking swift action instead of pushing it along. But the counter argument to that I hear is that the reason PTAB came into being is because there was a lot of companies that were getting sued were unhappy with being sued, with what they perceived was bad patents. And now this is just swinging too far in the other direction. it might come even swing even back, even harder and worse than it did this time around.
It's definitely problematic from the public perspective that every new administration can change the rate of invalidation of patents at the PTAB. That's why new legislation in this area is super important, because something that shouldn't swing like that. It's patent policy. It should be much more stable. Obviously, it's never stable, but at least in one respect, it could be.
And maybe that's a good place to finish it. The question is, this is where we are now on recording this in beginning of April 2025. And then we come back to this on beginning of April in 2029. The question is, where will we be with all these issues, with the backlog, with the state of the PTAB and all of that, and maybe some of this legislation that's there? Where will we be, and where do you hope we be, and also realistically, and where do you think we are in the path to that? Julie, maybe you could tackle that first.
I think we're heading straight toward the registration system. I believe the new administration is going to try to downsize across all aspects of government, the executive branch, all the departments, to the point that the agencies cannot function and do their work. And the argument then would be made, they're not functioning, doing their job as they need to be doing, let's privatize it. And along the way for the patent office, let's dumb things down to the point where we have a registration system. I've heard that that's what seems to be the ploy over at the FDA. These are agencies like the USPTO that have user fee funded sources, no taxpayer dollars being saved by firing a bunch of probationary people at the patent office. This is the inventor's money that they have paid into. And so this is very interesting times right now. South Africa has a patent registration system. And it's very interesting if you look into that. Right now, South Africa is trying to emulate our search and exam system. They're trying to upgrade to that. But these cuts, we've spoken about searching, the importance of searching the front end. We won't have the bad patent at the back end if we did the search right at the front end. And this month, they have canceled dialogue and STN searching for the biotech, chem, pharma examiners. The non-patent literature databases that these examiners routinely work on to find prior art. And the examiners are quoting on Reddit a statement to say no art was found given the amount of time given to use the search tools that are available. Without stick and dialogue, how are they going to find the prior art? It's a scary time when you think about America's patent competitiveness.
Yes. So I guess just with that, those are the tools that I guess those tech centers use for prior art searching outside resources. And I'm guessing that's something that does have to be cleaned up for good examination to happen in TC. At this point, we have seen an effort to at least preserve the examining corpse as much as possible. That is a concern, I guess, where might this go? Clint, do you have any thoughts about that?
Yeah, I would disagree with Julie there. I hope she's wrong. I think she probably hopes she's wrong too. But I could just see like a flurry of patent infringement lawsuits from trolls on broad claims that haven't been examined being extremely problematic. And then you could even imagine foreign countries getting involved, for example. Could you imagine like large Chinese entities filing tons and tons of patent applications and just suing like crazy? That would be terrible for the economy in the United States.
You're saying if they weren't examined? Yeah. Actually, I think Dennis Crouch was the first who floated this theoretical idea, but maybe the reason I'm skeptical of that is because obviously Howard Lutnick and Coco Morgan Stewart, they're huge believers in the patent system. And the reason the patent system works is because once you have a patent issued from the U.S. Patent Office, you can say, hey, the U.S. Patent Office examined this patent. It should have a presumption of validity. And if you take that away, if you go to a registration system, it becomes worthless. Nobody will take it seriously. And then how can you then rely on that property right to make those investment decisions and so forth if you don't even have that presumption that it was examined and that you have a valuable patent right? Not that it's perfect, but I think it would take us to a much worse place. I guess, Clint, do you have any thoughts about the backlog issue? I know it's hard at this point, but in terms of at least what the administration has been doing so far, where do you think we'll end up with that?
There's been backlogs in the past that have gone up and gone down. I think they'll get it under control, assuming there's some tweaks that are made to the system. But Coke Morgan Stewart has a lot of experience with the patent office. It's good to have. She'll be the number 2 when John Squires takes over the position. And I would imagine that he would trust her expertise. I think that she probably will be doing things to try to get rid of the backlog. So I don't think long-term that's going to be a huge deal. And I would imagine that they are going to adapt AI searching tools because, as you and I know, Eli, they've gotten a ton better over the last few years. So I think that the backlog will get under control. The other thing is I hope PARA, the 101 patent eligibility legislation, passes. I think it will pass eventually. And they're just, with the stories that I mentioned earlier, as far as having to appeal to the PTAB and deal with, quality assurance specialists, I think it's just inevitable that there'll be a change eventually because software is just too important to our economy. And it doesn't necessarily make sense that if you're developing software that, helps to aid manufacturing, why you would necessarily need to do the actual manufacturing to have somebody infringe a product. It just doesn't make any sense to me. So I'd like to think that it'll get passed eventually.
Julie, are there things that I guess stand out to you that, hey, these are the things that the USPTO maybe, I know you mentioned a bunch of ideas, but anything stands out, hey, this is what they can do to maybe tackle the backlog issue even more effectively?
I think it's changing the paradigm from thinking we have bad patents to what about the state of the rejections? We just got OPQA data for 2024 on the quality of the rejections versus the quality of allowances. So yes, we do have 8% of the allowed patents OPQA said are not in compliance with the statute. That's an 8% error rate for allowances. That's very troubling. It used to be, by the way, they measured it and such, 97%, 98% of the patents met the quality components. What's really shocking is that 20% of the rejections do not comply with the statutes. And so this means that there are claims that should be patented that are not getting patented. And it's a much bigger problem of things trying to get through the system to first get the patent there. OPQA drills down deep. 31% of the final enablement rejections are flawed. And why is applicants and attorneys spending time responding to those, and why that takes time and effort to write those enablement rejections? And if there would be some sort of way to streamline a path for early allowance of applications, identifying allowable subject matter early on, training the patent examiners right in the front door. You're a patent examiner and you allow applications. My mentor, Robert Budens, who was president of POPA for many a year, back in 1995, had the USPTO shield up on his wall, U.S. Patent and Trademark Office, and he took his Sharpie out and he turned it into the U.S. Rejection Office because there was that culture. There is that culture. If examiners feel safer to reject than allow, that's what they're going to do. So I feel like there's a cultural shift because definitely help address this backlog.
That's great advice. Just to double down on that point, I think the Center for Innovation Promotion, that's a center run by former directors Kappas and Iancu, they recently, cited a study by the Sunwater Institute, which kind of supported that point, that actually it seems the much bigger issue is not issuing bad patents. The bigger issue is actually claims being rejected that shouldn't have been rejected. That's a much more significant issue. And the USPTO should reflect that reality and be U.S. Patent Office, not the U.S. Rejection Office. That's it. Any other final thoughts? Anything else, I guess, if Clinton maybe on your mind?
If I could follow up on that, actually, I have a friend who's been an examiner for years. And so when I got analytics tools, I sent him his analytics showing that he had a super low allowance rate for a number of years, and then it jumped up. And he was like, oh, no doubt. It's because I had a primary that was above me that took the viewpoint that if you can find the art and you can piece it together, you should reject the application. His allowance rate jumped when he came under a new primary that said, no, you don't just take that process. It's not a puzzle that you're trying to figure out. You try to look at the references and decide whether one of skill in the art would have combined them, which is obviously the correct process. So I think Julie's right. If you can get away from that rejection mindset as opposed to getting it right, then I think that goes a long way.
Any other final thoughts or anything else we haven't covered?
Oh, Eli, thank you for hosting this. I feel like you could have one of these every single week at the rate of change we're seeing with this new administration. And it's going to be very interesting and very important to see how things progress.
I agree. And thank you, Clint, and thank you, Julie, for commenting on Clause 8. This was a great discussion. And I think Clint's point there at the end and what Julie said about changing the culture, empowering the examiners will have a big impact. I'm often accused, rightly, of being overly optimistic. I am. I think some of the broader dynamics that you see at play might not impact the USPTOs badly, and hopefully when we discuss this in April of 2029, that'll be the case. But thanks for coming on Clause 8.
Thank you so much for listening to this season of Clause 8. Eli will be back soon with more episodes. In the meantime, you can keep up with Eli's thoughts on all the changes in the industry at voiceofip.com.